on this morning's Ag Issues program. A pleasure, as always, to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Nice and chilly this morning.
Yeah, exactly. And let's get into
degrees here.
What was say that again?
It's 57 degrees here this morning, Greg. Going
57.
to 79.
Man, oh man. All right, let's get to it. We've got a lot to talk about. Easement issues arise frequently in agriculture, and probably many listeners have sit there and had a situation like that. But often, Roger, the easement involves a lot of times access to a landlocked parcel. So in this case, we're talking about prescriptive easement and adverse possession as well.
Yeah, Greg, and finally, after decades, the Kansas Supreme Court gets it right. This is something that I've been talking about to my students. I've done this in K-State extension meetings for years, just saying, look, we've got a court that has screwed up adverse possession and prescriptive easements for decades. They have blurred the concepts. Not sure what I can tell you as farmers because it's wrong, and hopefully one day they will clear this up. And they have finally done so. One of the justices from the Smith Center area and a Washburn Law School grad clarified this and cleaned up the mess and just said, look, we've been wrong for decades. We're going to straighten this out. And let me explain what this is. There's a distinction between adverse possession and a prescriptive easement. Possession means that I'm trying to claim somebody else's property as my own by possessing it. So I'm claiming ownership adverse to the true owner. An easement's different than that. An easement is just a use right. And so maybe I've got a landlocked parcel of real estate that I need to, because of a stream, for example, which was the situation in this case we're going to talk about. I've got a parcel I can't get to a field that I own, and I need to come across somebody else to get there. So one way to do that is, of course, approach the neighbor and say, look, I need an easement to get to my small acreage back there. Maybe I'm haying it or whatever the case might be. I'm landlocked. I'm cut off by water. I've got to come around onto you to get access to it. And they might say, well, that's fine. We'll grant you an easement. We'll even sell you access rights. That would be the smart way to do it. For a fee each year, you can do this. And we can change the deeds to reflect that and have that one tract subject to an easement. Or the other approach is to say, no, you're not going to do that. And the other party continues to do that. And you end up court and paying a bunch of lawyer fees, which is what happened in this case. But the point is, with adverse possession, one of the key elements of that, and it's an ancient property law concept, and just about everybody listening knows the basics of adverse possession. And one of those for adverse possession is that my use has to be exclusive. I'm claiming ownership of this tract adverse to you. You're the true owner, but I'm sitting in here using it and claiming ownership, and I'm keeping everybody else out. I'm claiming exclusive use of this. That concept doesn't apply when it's an easement, and that's the scenario I've tried to pound into the heads of my students. An easement, it's just a use right. So somebody else could be using that easement to get access to their field, for example, but that doesn't interfere with my use of the easement. So there is no exclusivity requirement when it comes to a prescription, an easement by prescription, although the court for years had just blurred the two together and said, they're kind of the same. Well, no, there's not. And thankfully, the court has now clarified that up. And so we get this case from Northeast Kansas, and it actually involved an individual that's in the Kansas legislature that had farmland, but they were disputing the location of the property line between their tracts, which is usually how this starts. And the plaintiff in this case would routinely plant crops up to what he believed to be the property line, but the planting interfered with the crop farming plans of the defendant's tenant. And the plaintiff also regularly used a portion of the defendant's field as a road to access his crops because he was cut off by a stream. Well, he offered to, the defendant actually offered to sell the disputed area to the plaintiff, and the plaintiff said, no, I don't want to buy it. I just need an access right here. And so then the defendant tells the plaintiff, well, stop accessing my crops by my field. And so it turns into a mess like these deals do, and each party hires surveyors, and the surveyors couldn't come to the same conclusion as the property line. And so the defendant in 2016 puts a fence up based on the property line that his surveyor found, which was 17 feet beyond what the plaintiff's surveyor believed the property line to be. So now you get into court. And so back in 2017, the plaintiff sued the quiet title to the field up to the crop line that he farmed by adverse possession, and then sought either prescriptive easement or easement by necessity. So they're throwing all these concepts in there as a result of the confusion that the Kansas courts have created over the years. We don't know whether this is adverse possession, whether it's prescriptive easement, whether it's an easement by necessity. And it goes to trial. The trial court said that the plaintiff had adversely possessed the land in dispute and had acquired a prescriptive easement across the defendant's property. And it goes on appeal then to the appellate court. They upheld the trial court's determination that the plaintiff had acquired that little strip in question by adverse possession because he'd used it for the 15-year statutory time frame in Kansas. It was open, exclusive, continuous manner. He believed that he was the true owner of it. And the fact that others were using that for recreational purposes, the appellate court said, now that didn't negate the exclusivity requirement. Again, they're still thinking that there is such a requirement because that wasn't very frequent. That was just infrequent compared to the plaintiff's farming activity on that disputed strip. Now, the appellate court did reverse the trial court on the prescriptive easement issue because both of the parties used the alleged area, this area in question on which that prescriptive easement was being asserted. So the plaintiff hadn't used the easement exclusively. And again, there's that confusion. And when I read that opinion, that was the appellate opinion last year. It's like, oh boy, here we go. It's just more confusion. But it gets to the Supreme Court and they reversed that. And they said, finally, there is no exclusivity requirement as an element for claiming a prescriptive easement. There is for adverse possession. So if you want to claim ownership of somebody else's property that you know is theirs, and so it's truly adverse, there is an exclusivity requirement. You have to keep everybody else out of what you're asserting you own. But that's not the case with an easement.
And there's, understand also another case concerning adverse possession that was recently, the decision was rendered recently in Texas, too.
Yeah, this was a Texas case, and the point on this one was you can assert adverse possession by cattle grazing. And that's an interesting case, and that just shows what the usage was in that situation. This was a large ranch and then a smaller property that adjoined each other, and they had a little bit over 20 acres that were in question. And based on the testimony, a lot of these cases on property usage and ownership are going to be based on testimony of people that have been there a long time. And the testimony revealed that the fence at issue had actually been put up in 1903, and the rancher with the large tract who was grazing cattle had grazed cattle on his property, including this disputed 20-acre tract that the other party claimed that they owned. And he had fixed the fence, repaired the fence, did a lot of work with respect to the fence over the years. So it wasn't just what they call in Texas a casual fence between the parties, but it was actually intended to restrain livestock. And just based on the testimony and based on the length of time this individual had used that fence as a border fence since 1959, it easily met in Texas, 25-year statutory time frame for adverse possession. So that's one where the requirement was just satisfied by the usage over a long period of time, and cattle grazing satisfied that.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. And Roger, during this time with the inflation in the economy that's taking place, obviously that's resulting in increasing grain storage costs at elevators. And, well, it's simultaneously in a grain market where grain priced under forward grain contracts for future delivery is priced lower than some of the current spot prices we see.
Yeah, we've got an inverted grain market right now, and so that incentivizes farmers to sell right now instead of pricing that out in the future. So it does increase and the inflation in the economy does increase the cost of handling that grain by the elevators. So their cost of borrowing has risen because of inflation in the economy. Crop prices are high, so to alleviate that pressure, they raise the storage cost. Now, based on USDA's marketing year average prices, the interest-related cost of storing grain is up 21% for corn, 42% for soybeans, and 50% for wheat. And that's a real problem, especially for cooperative elevators, because their business is to buy and market their members' grain. That means they have to carry inventory even if the cost has gone up. And so you got a real problem in the grain industry right now, and all of this is going on while farmers are facing higher input costs. Now, some of the input costs are down from last year, especially fertilizer, but on the whole, they're still very high. So lower bids for outputs and higher costs for inputs, that's not a good scenario for farmers. It's a tough scenario for grain elevators. And so one of the things that we need to think about is what can a farmer do to minimize risk in this situation? What can an elevator do to minimize risk? But with respect to farmers, I would say one thing would be to examine your strategy for using forward and deferred payment contracts. Are you optimizing those out? And there's a rule when we get into deferred payment contracts is that once you meet, of course, you have to have a practice of deferring your grain sales to be able to enter into a deferred grain contract and get the same tax result to move that income into the next year. But once you meet the threshold test for doing that, then you either defer everything under the contract or you don't. And so one thing that farmers should be looking at is if they have multiple crops, use a deferred payment contract for each crop. Don't put everything on one contract, because if you have everything on one contract, you have no option. You will either defer everything or you will report everything this year. And that may not be the best scenario for you from a tax planning standpoint. So have a contract for each separate crop, and then you can still get to the end of the tax year if you're on the calendar year. Most farmers are. And then determine, well, you can look at your tax situation for the year and then determine whether I want to pull the income from one contract into income this year by electing out of the deferral treatment, or just continue to defer. But we can do that on a contract-by-contract basis. So I think that becomes more important in this type of an economic scenario that we're in. The other one is to make sure that you're optimizing your depreciation alternatives, 179, expense method depreciation, bonus depreciation, the difference on regular makers between new equipment and used equipment. And are you optimizing your use of the commodity futures market? I think all of those concepts together become more important now, given the type of environment that we're in, and with farmers facing higher storage costs. It's going to change the thought process as to what a farmer needs to do to continue to be as profitable as they possibly can in a very tough environment.
And Roger, as we wrap this up, of course, you and I have talked about the U.S. Supreme Court decision on the California Prop 12 case. But this is also a reaction to that. That, of course, is the Ending Agricultural Trade Suppression Act, known as the EATS Act, that has been introduced both in the U.S. House and Senate. There is a possibility, or at least it sounds like, due in part with the discussion still yet to come on the Farm Bill, that it could be included in Farm Bill legislation.
Well, it's possible, and that presupposes we'll actually get a farm bill this year, which I'm not convinced that we will. In fact, I don't think we will at all this year. I think they'll just push it off into the next year. But yes, this is in the wake of the U.S. Supreme Court's decision on the Prop 12 case a couple of months ago. And it's been Senator Marshall that has introduced legislation in the Senate. It's also been introduced on the House side. that would try to limit the power of states to establish their own standards for ag products. And of course, if people aren't familiar with what California's Proposition 12 was, what they're saying was that you can't sell pork products in our state unless it was raised in accordance with our standards. And so, that's kind of the short version of what Proposition 12 was all about. And so the Supreme Court upheld that. Frankly, I think it was argued incorrectly. There was a better way to argue that case that would have probably picked up 2 more votes and swung the case in agriculture's favor, but nevertheless, it didn't. And so we're dealing with this, and what's the possibility of other states doing the same thing? There's a concern about this. Well, all of this could have been short-circuited. We would probably never had the case had the Congress passed Steve King's legislation, Congressman King out of Iowa, about 7 or 8 years ago. And that didn't get through the Senate, and so it never got into a farm bill. What the EATS Act is the current version of the King legislation, and they're both designed to prioritize economic incentives for the production of ag products and avoid states from legislating their morals, so to speak, on other states, and let consumers decide the ag products they want to buy. Now, that assuming that consumers have full knowledge and the products are appropriately labeled. So, in other words, if in California, if I don't want to buy pork products from the state of Iowa, for example, because I don't like the sow crates, the size of the sow crates that the sows are in while they're birthing, then just label the stuff as it comes into California. Let the consumers choose what they want. But that's not the approach that California took. They just said, no, if you don't raise in accordance with our standards, you can't come in. And by the way, we're a big market. 13-14% of consumption of pork products occurs in California, but they don't raise hardly any pork products at all. And so the effect of this doesn't hit any California ag industry hardly at all, and that's the problem with this. So the objective of the law is to prevent states from enforcing regulations on animal products that are produced outside their borders and then imported for sale within the state. So it's an attempt to make sure that this problem that California started doesn't expand, and we have what's called economic cannibalization of various states going after other states.
And as we have seen here, at least last week, the animal rights organizations pretty vehemently opposed to this.
Yeah, they don't like it at all. And so there's going to be a heated debate about this when we do get down to serious discussion about a farm bill.
All right. And Roger, all we discussed is in your latest blog as well. So if they want to read that and other things that you have posted pretty on a regular basis, what's the best way they can do that?
Well, 2 ways. You can go to my website, which is washburnlaw.edu/WALTR, or over at K-State, the Ag Manager website.
All right, sounds good. Well, Roger, enjoy that 57-degree weather this morning, and we'll talk to you here in a couple weeks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.